Well, you probably saw this coming. The 4 police officers involved in the death of George Floyd have now been federally indicted by a grand jury. That means they will stand federal trial for different crimes related to the civil rights violations against George Floyd. These charges are separate from the state charges. As you know, Derek Chauvin was convicted of second-degree murder, third-degree murder, and second-degree manslaughter in the death of George Floyd. The other 3 officers have been charged but have not yet stood trial for aiding and abetting said murder and manslaughter. The federal charges are not for murder or manslaughter or aiding and abetting. They are related to deprivation of civil rights. As we go through this video, we're going to take a look at the indictment. We'll talk about the specific charges, but I'll also talk about the genesis of these civil rights charges in general, and I'll tell you what I think about the charges against the different officers and all of that stuff. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator on YouTube and on Odyssey. Check me out, Rekieta Law on YouTube, Rekieta Law on Odyssey. Then when you get there, hit the like button, the subscribe button. Go ahead and share it with other people so you don't miss any videos and so everybody else you know can be informed on these subjects, all right? Okay, here we go. By the way, the 2 sources for this one is from the Associated Press article. We're only going to read a little bit of it. You can check it out in the description below if you really want to go ahead and explore the article further. And then the other source is the indictment document, which will also be linked in the description below if you want to check it out. But we're going to go through that whole document here in this video. All right, it's not very long. So 4 ex-cops indicted on U.S. civil rights charges in Floyd's death. Federal grand jury has indicted the 4 former Minneapolis police officers involved in George Floyd's arrest and death, accusing them of willfully violating the black man's constitutional rights as he was restrained face down on the pavement and gasping for air. A 3-count indictment unsealed Friday named Chauvin, Thomas Lane, Jay King, and Tu Tao. Chauvin, convicted last month on state charges of murder and manslaughter, is charged with violating Floyd's right to be free from an unreasonable seizure and unreasonable force by a police officer. Tao and King are also charged with violating Floyd's right to be free from unreasonable seizure, accused of not intervening to stop Chauvin as he knelt on Floyd's neck. All 4 officers are charged for their failure to provide Floyd with medical care. Floyd's May 25th arrest and death, which bystander captured on a cell phone video, sparked nationwide complaints about the police treatment of black people and protests calling for an end to brutality and racial iniquities. Chauvin was also charged in a second indictment stemming from his use of force and neck restraint of a 14-year-old boy in 2017. That 14-year-old boy was also 6'2" and 240 pounds, according to the indictment. But we're not going to talk about that one too much because I need to look into that topic a little more, maybe for another video. Right now, we're talking about these officers and this indictment. So here is the indictment. It was just unsealed. And we've got some general allegations. We've got specific allegations. Let's get into it, okay? But first, actually, let's talk real quick about the genesis of these deprivation of civil rights and where they came from. These laws came out of sort of the transition from the Jim Crow era into the civil rights era. And what they were intended to do was to give a federal remedy when quote unquote good old boy courts in the South would refuse to convict someone who was charged with a crime if it was a white person versus a black person. Generally speaking, that was the intent. So the idea was that there was a racial animus or a racial undertone to the criminal charge, and they were let off by a white jury, for example, during the early civil rights years. That has largely not been a problem in the United States, in my opinion, for really quite a while here. We have several examples of it. I know there are people who say there's disparity in sentencing and disparity in convicting in the courts, and there is an argument about that. But generally speaking, the way these were constructed was the idea that a literal white jury would not convict a white person for a crime against a black person. And so it gave the federal government the opportunity to intervene in cases like that. Again, I think that those cases are something of really of the past, generally speaking. But the laws are still around, and they do still give the federal government license to come in when they believe there's an issue of race. So make no mistake, the race of George Floyd is the critical element of these charges, or a critical element, I should say, of these specific charges. The charges rely on the protected federal classes, race, national origin, religion, stuff like that, to actually take effect. So that's where these things came from. That's where the charges are going to relate, and that will be part of the elements of the crime, which could actually be difficult for the police, is to show that this was in relation to specifically Mr. Floyd's skin color, which I haven't seen any actual evidence that the whatever happened, even if you consider it murder, if you consider it manslaughter, or if you consider Derek Chauvin an innocent man, I haven't seen any evidence of racial animus towards George Floyd from any of the officers. There's no statements that were entered into the record that I'm aware of. There's no like text messages or writings of the officers that would suggest that there was a specific racial bias or racial animus at play. So I think the feds are going to have some issues with that. But let's take a look at the charges. Okay, so we've got the defendants being identified as police officers. We've got Floyd being identified as a resident of Minnesota. So count one is deprivation of rights under color of law against Derek Michael Chauvin. And this is probably the best case the feds have, because he was convicted in a court of law for murder, manslaughter, and, murder and manslaughter, the two murders. Sorry, that was the and. Because he was convicted of those crimes, they now have knowledge, like a court record, that he did actually engage in excessive force. And that's one of the elements of this crime that they have to get into. So they now have a record they can point to. His conviction for the excessive force is there. There's a whole bunch of evidence that's in that court record that they can bring into this case for that. So that's why I think that this is the strongest charge. But while acting under color of law and while aided and abetted by officers known to the grand jury, willfully deprived George Floyd of the right, secured and protected by the Constitution and laws of the United States, to be free from unreasonable seizure, which includes the right to be free from the use of unreasonable force by a police officer. So had there not been an unreasonable force element in here, then the seizure of George Floyd would be entirely reasonable. He was committing a crime. They were effecting arrest. That is fine. So this charge relies heavily on the idea of excessive or unreasonable force being used in that detention. Specifically, defendant Chauvin held his knee across George Floyd's neck and his right knee on Floyd's back, or his left knee across George Floyd's neck and his right knee across Floyd's back and arm as George Floyd lay on the ground, handcuffed and unresisting. I mean, there was some resistance at the beginning, but that being said, and kept his knees on Floyd's neck and body even after Floyd became unresponsive. This offense resulted in bodily injury to and the death of George Floyd. So that's count one. And I do think that, especially given the existing conviction, is a pretty strong case against Chauvin. Now, of course, if he were to get a mistrial and to have that conviction thrown out, that would change things quite a bit. So that analysis can change as we move through the process. As you know, or should know, I guess you could check out my video on it. There is a motion to, there's an existing motion to declare the trial a mistrial for juror misconduct and stuff like that. The memorandum of law has not been released on that, and I will cover it when it comes out and we get the full scope of that motion. But right now, there is an existing motion to go ahead and have the conviction thrown out. We'll have to see what arguments Eric Nelson brings in that forthcoming document to assess the chances of it. So as for Tu Tao and Alexander King, while acting under color of law, willfully deprived George Floyd of the right secured and protected by the Constitution and laws of the United States to be free from an unreasonable seizure. Specifically, King and Tao were aware that Chauvin was holding his knees across George Floyd's neck as Floyd laid handcuffed and unresisting, and that Chauvin continued to hold Floyd to the ground even after Floyd became unresponsive, and the defendants willfully failed to intervene to stop Derek Chauvin's use of unreasonable force. This offense resulted in bodily injury to and the death of George Floyd. I think this is much more difficult. Much more difficult because we do actually have evidence of the officers attempting to intervene, informing Derek Chauvin that there was no pulse, suggesting they move him to a different position once they had gained compliance, things like that. That exists. That happened. And because that happened, it's on video. There's audio of the officers questioning Chauvin's, actions and him shooting down those questions. As the senior officer on scene, I think these guys have a much better chance against the charge that than Chauvin does against his. And I think that's true for the state aiding and abetting charges as well. I think there is significant evidence that these officers were attempting to, under the hierarchy of the police structure, make some alternative suggestions. So I think that takes away the willfulness of their failure to intervene. Remember, that willful aspect is important. It's not just that they failed to intervene. It's that they willfully chose not to. I'm not so sure they did. They did attempt to intervene in some way. Now, that intervention may have been insufficient, but does that rise to the level of willfulness? I'm not sure about that. That'll be one of the big hurdles here. And again, the main hurdle in all of these cases is proving the underlying racial purpose for their deprivation of civil rights of George Floyd. All right, so here we have count 3. This is against all 4 officers. It says, while acting under color of law, willfully deprived Floyd of the right secured and protected by the Constitution and laws of the United States not to be deprived of liberty without due process of law, which includes an arrestee's right to be free from a police officer's deliberate indifference to his serious medical needs. Specifically, the defendant saw George Floyd lying on the ground in clear need of medical care and willfully failed to aid Floyd, thereby acting with deliberate indifference to a substantial risk of harm to Floyd. Again, as to the other 3 officers, I think this one gets really hard to prove, but this is another one that they have against Chauvin that is a pretty strong case. And I think it was actually the stronger case in the state for the manslaughter too, is that failure to provide the necessary aid to Mr. Floyd once Chauvin was aware that he was unconscious or non-responsive. I think that's when the manslaughter charge kicks in. He's created a situation whereby Mr. Floyd cannot care for himself. Therefore, he has assumed a duty of care and he failed to provide medical care. Now, again, I'm not saying it's a slam dunk case either way. He was convicted of this, but that I think is a better case than some of the other stuff that's going on here. For Chauvin, both of these are big problems because of his underlying convictions for basically the similar elements of a different crime, right? That is a problem for him here. But for the other 3 officers, again, I think those mitigating factors are still present. You do have the officers expressing at different times concern for Floyd's well-being, checking his pulse, checking his responsiveness, suggesting other things, and then Derek Chauvin shooting them down. In fact, the other officers will likely and should, as a legal strategy, whether they will or not is, I guess, an open question, but as a legal strategy, will probably want to throw Chauvin under the bus here, because their innocence depends on them having made these suggestions, having shown an interest in George Floyd's medical condition. So with this, I think the other three officers, it's different for each one because they all responded and said different things, and that'll have to be sussed out more clearly with a factual record. But I do think that the three other officers have a chance of beating these charges. Whether or not they will is a different question, because having a legal chance of beating charges and actually facing down a jury who can have various biases can be a different story. So we'll have to see how that goes. But that is the indictment. It has been unsealed and filed, and now these officers are charged federally with that. So that's it. I hope you found this informative. Just as a brief recap, these are civil rights era laws that came about because white juries in the South were not convicting, when people were charged with crimes against black victims, I should say. And so these laws exist. I really don't think that is a problem. I don't think we have, and certainly not in Chauvin's case, right? We do not have all white juries protecting white defendants in the way that was existing in the 50s and 60s. It's not the same sort of scenario that we've got. We've come quite a long way in that. Even though there may still be some sentencing disparity and there's a discussion to be had there, I don't think anybody can seriously suggest that we're the same place we were 60, 70 years ago in regards to juries and white defendants. I don't think that's a real thing. But that being said, that's where these laws came from. All four officers are charged. I think Chauvin, of course, faces the biggest uphill battle with his underlying convictions. The other officers also have Chauvin to throw under the proverbial bus. Plus, they have some exculpatory evidence of their own in that they made statements showing concern for the condition of George Floyd, and those statements were shot down by Derek Chauvin. So that combined makes me think the charges against the other three officers are weaker. And I think the same thing in their state charges, by the way. I think similar analysis applies. We'll have to see how it pans out. But that's what we've got for the day. Drop a comment down below. Tell me what you think about all of this. Tell me what you think about each officer's chances. I'd love to hear from you guys. And until next time, peace. Peace.